Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Recently, a subscriber asked me if I could do a video on the defenses to fraud. That was after I had done a video about how difficult it is to prove fraud. So I told him I would look into doing that, and today looks like it'd be a good day to do that. Defenses to fraud usually attack the elements, which I'll get to in just a moment. But the standard defenses that are always available on any claim are available in a fraud claim too. The statute of limitations applies. If your state has a statute of repose, that's going to apply. If you have an issue with the jurisdiction of the court, personal jurisdiction, subject matter jurisdiction, all of these defenses are available to someone who is sued under a fraud claim. You have to have the right defendant. So if you have been sued in your corporate name and they've got the name wrong, that's another defense. And there's also a requirement anytime you bring a fraud claim that the complaint be pleaded properly, which we'll get to in a moment. So fraud is an intentional tort that has 9 elements. And those elements are a representation, its falsity, its materiality, the speaker's knowledge of its falsity or ignorance of its truth, the speaker's intent that it should be acted upon by the hearer in the manner reasonably contemplated, the hearer's ignorance of its falsity, the hearer's reliance on its truth, the hearer's right to rely on its supposed truth, and, of course, the consequent and proximate injury that results from being defrauded. A plaintiff alleging fraud is required to prove each of the 9 elements in order to be successful in his claim. A failure on any one element means the claim fails. Then we get to the pleading rules. Every state has a rule in pleading that says you have to allege fraud with specificity and particularity. And indeed, the federal rules, Federal Rule 9b, also says that fraud has to be pleaded with particularity. So, to successfully allege a claim for common law fraud, a plaintiff has to plead each element in that manner. That means they have to plead the who, what, when, where, and why, and sometimes the how of each one of these elements, with one exception, and we'll get to that in a moment. For example, New York law requires a cause of action for fraud to be pled with greater specificity than other causes of action. Each element must be supported by sufficient evidence, and fraud can never be established by doubtful, vague, speculative, or inconclusive evidence. However, fraud may oftentimes be inferred from circumstantial evidence. And what that means is that you don't have to have direct proof that many times some of these elements, particularly state of mind and intent, can be inferred from the actions of a party. Conclusory language will not satisfy the particularity requirement of a common law fraud claim. That's because mere conclusory allegations in a pleading, unsupported by a recitation of relevant surrounding facts, are insufficient to prevent a summary judgment against the plaintiff. A conclusory statement is something like, defendant made a false statement of fact as pleading an element. Well, that doesn't specify who made the representation, when it was made, to whom it was made, how it was made, in other words, what language was used, and sometimes why it was made. They were selling a car, for example. All of those elements have to be included when someone pleads a claim with particularity. And oftentimes lawyers get lazy. Under the federal rules, Federal Rule 8 says you have to have a short and plain statement of the claim, but then Federal Rule 9b says if you're pleading fraud, it has to be with particularity. So the whole idea behind the federal rules was just to give notice that you're being sued, and then you flesh out the elements of the claim in discovery, with that exception being in fraud, you can't do that. So if you get vague pleadings and they don't say the who, what, when, where, and why of each one of these elements, then one of the defenses that your lawyer is going to do is going to be, hey, you didn't plead this with particularity and it should be dismissed. Now, the upshot of that is that in almost every instance, the court is going to give the plaintiff an opportunity to amend their complaint, unless it would be, unless it would not matter if they amended the complaint. If it is not something that can be cured with an amendment, they don't always grant that kind of relief. So defenses really begin with the elements themselves. And the first element, a representation of fact, would sound like a pretty easy one to do, but not always. Because a representation of fact is, there are no known defects with this automobile. But the statement, I'm pretty sure this car will run for another 100,000 miles, is not a statement of fact. It's an expression of an opinion only. It's forward-looking, indicating that something will happen, but again, it's probably beyond the actual knowledge of the person who's making that claim. And so, because it's an opinion, in many states, that's not going to be actionable. As such, it's not a fact when people offer their opinion. And knowing the difference between facts and opinions is a key part of understanding these defenses. Anytime you spend money on something big, a car, a house, that sort of thing, and you are offered opinions, nail them down instead on the facts. What repairs have been made? Has the engine of this car had regular maintenance? Show me the records. Facts are the linchpin of a fraud claim. Now, not all forward-looking statements are immunized. For example, a statement like, if you have trouble making the payments, we'll adjust the car loan for you, is actionable if, at the time they make that statement, there's no protocol for doing that, and it's just somebody blowing smoke. Now, a representation can also include a party's failure to disclose facts. If you have a duty to represent something, then, and you don't represent it, it can be a misrepresentation. The second element is falsity, and it can be attacked by showing the statement was not false when it was made. But even this may not always be enough. While an honest mistake may have some jury appeal, a defense of mistake or forgetting to act on a promise can also sometimes be fraudulent. You really need a lawyer to guide you in this area, because the law is sometimes difficult to understand when it comes to fraudulent conduct. The third element is materiality, and it's also subject to defenses. A material representation is a representation to which a reasonable person would attach importance in deciding his or her course of action in a transaction. Materiality really has more to do with whether the statement is important in the grand scheme of things. For example, a statement that the truck had chili red paint, only to find out later that it was fire engine red paint, would not be material because the truck is still red. For that reason, materiality can sometimes be viewed through the lens of importance. The fourth element, knowledge of falsity or ignorance of truth, is another fertile ground for defense in these cases. Because it's important for the alleged fraudster to know that the statement they're making be untrue, or, in the alternative, to have acted in reckless disregard of whether it was true or false, the way to attack this element is to show that, first of all, you didn't know the statement was false at the time that you made it, but you had done some investigation. You investigated, but you held honest but incorrect beliefs about the status of things. For example, you may not have known that a prior buyer rolled back the odometer. If you can demonstrate or testify that you examined the car, you didn't see anything that would have indicated to you that the car had more miles on it than was on the odometer, and you didn't get a statement from the previous owner that the odometer had been rolled back, well, you are absent knowledge. And perhaps even more important, you weren't reckless. In other words, you didn't just take his word for it. You looked the car over. You didn't see anything that would lead you to believe that it had more miles on it than it actually did. So that's one way to attack it. You have to be able to avoid this reckless disregard thing. So you have to be able to show that you made some investigation. And a mistake of fact, or a mutual mistake of fact, a mistake in the interpretation of data, is not fraud. It's just a mistake. The fifth element, intent, is often difficult for the plaintiff to prove. Courts say that the fundamental character of fraud is the communication of a misrepresentation with the intent of the other person to rely on it. And they also say an unperformed promise does not give rise to a presumption that the person making the promise intended to perform when the promise was made. A defendant who acts with knowledge that a result will follow is considered to intend the result. Now here, one of the most important and useful ways that you can defeat this claim of intent is to have a disclaimer. Whenever you sell anything, you have a disclaimer that says, you are not relying on any of my representations. You agree that you've had an opportunity to inspect the property or the vehicle or whatever and get an independent evaluation of the status of this particular piece of merchandise, whatever it is, and you are not relying on my representations in making your decision. That takes your representations out of the mix and intent goes away at that point. So the sixth element of a fraud claim is the injured party's ignorance of the falsity of the statement. If the plaintiff knows the statement isn't true or has reason to know, then there's no fraud. So if you're talking to a person and they say, well, I knew the guy had to be telling me a story when he said this car had 20,000 miles because the tires were bald, and obviously tires don't go bald in 20,000 miles, then the person was not defrauded, they're just stupid, because you don't buy a car when somebody lies to you about the status of the car. So if you know that a person's statements are untrue, or you have reason to know, for example, the tire tread on the car, then even if the representation is false, a cause of fraud will not exist. So in defending this, obviously what you can do is say, they should have realized that I had misspoken. There was evidence from which they could have determined that my statement was made in error. And as a result, I should not be held to account for the fact that they did not make an appropriate investigation, or they did not look at this in the way that they certainly should have. The seventh common law fraud element is the injured party's actual reliance on the truth of the representation. Courts say that actual reliance occurs when a misrepresentation is an immediate cause of the plaintiff's conduct and it alters his legal relations. And absent such representation, he would not have, in all reasonable probability, entered into the contract or the transaction. Courts have also said it's not logically impossible to prove reliance on an omission. Indeed, a plaintiff need only prove that had the omitted information been disclosed, one would have been aware of it and he would have behaved differently. And here the defense is to use the discovery process, particularly the interrogatories, requests for production, and the deposition, to essentially get the party who is suing you, the person who claims to have been defrauded, to admit that they didn't rely on your representations. Now, sometimes that's easy because they'll go in and say, well, I really wanted this truck and it really wouldn't have mattered what he said. And in that flash of honesty, their plaintiff's lawyer's head goes, and the case goes right out the window. But essentially, even minor admissions about, well, yes, I knew this and I knew that and I knew the other thing. And essentially what you're trying to do is get them to, in some substance, admit that it wasn't their reliance on your statements that sealed the deal for them. It was the fact that they needed or wanted the particular piece of property or the item that was at issue. And that's also a very credible way to defend against the reliance. The next issue, the right to rely, is perhaps even easier. That's especially true, like in the case of somebody selling a house. You essentially tell them to go get an inspector to come and do an inspection, and most realtors do that as a matter of course. Have an inspection, have somebody go through the house, check it over, make sure that there are no hidden defects or latent defects in the property. And if you do that, then you are not relying on the representation that there are no defects. You are actually verifying it, and you have no right to rely because you made an independent evaluation. Finally, one defense that we haven't talked about yet is when the claim of fraud arises in the context of a contract. Now, a lot of times people write out contracts. When you buy a cell phone or when you get cellular service, there's a contract involved. When you buy a house, there's a contract involved. When you do a lot of different things, most purchases, well, I wouldn't say most, I guess many purchases involve a contract. And the contract has representations in it, usually. And in addition to the representations in the contract, there are disclaimers where they're saying, you're not relying on anything that we say here. But even in those circumstances where there is some kind of real obvious misstatement of fact, sometimes a salesperson will tell a client, don't worry about that stuff in the contract about needing arbitration or any of that stuff, because nobody ever does that anyway. It's not a big deal. Don't worry about it. Those kinds of statements can get somebody in trouble, but they are usually considered to be statements of opinion. We've already discussed that. But there's an even more fundamental defense here, and that is a contract defense. If somebody breaches a contract, the remedy for that breach of contract is a breach of contract claim. It isn't a fraud claim. Just because somebody breaches a contract doesn't mean that they intended to defraud you. It means that for whatever reason, they are not able to fulfill or did not fulfill their obligations under the contract, and in that situation, you can make the credible claim that their only remedy is for a contract remedy, which is going to be money damages based on the benefit of the bargain. It is not going to be things like emotional distress and other damages that might be available in a fraud claim. I had a case several years ago where I believed that the defense of the fact that they had a breach of contract action was a complete defense to the fraud claim. The only problem was that the lawyer who represented this party in the original action in the trial court did not assert that as a defense, and so I was unable to assert it on appeal. There are all kinds of different contract defenses, and it is an excellent idea to, whenever you have a situation where someone's breached a contract or where you feel defrauded, to go see an attorney and have them evaluate your claim. Most plaintiffs' attorneys will do that for no charge. They will look at your case and tell you whether or not you have a case, and the only thing you have to do is agree to a contingent fee contract if they indeed determine that you do have a case, which is a pretty good way of getting the problem solved. Not everything that's a misstatement is fraud, and not everything that's fraud is subject to being rectified in court, because unfortunately there are a lot of people who are really good liars, and that needs to be something that people understand when they think about bringing these kinds of actions. But the key thing I want to point out here is there are 9 badges of fraud, and each of those has multiple defenses. It has multiple ways that the claim can be made, and you really need an attorney who does fraud work in order to help you with that kind of problem. So that's what I have for you today. If you have any questions, leave them in the comments down below. Like, share, subscribe, all that stuff everybody here on YouTube asks you to do. I try not to do that until after you've actually seen the program, although I do sometimes put up that little red banner in different places in the video just to kind of remind you, hey, if you haven't already, you need to subscribe. And I love it when people like it. But I really appreciate all the comments I've been getting. Those are fantastic. I try to get to as many of them as I can, but there are only 24 hours in a day. So thanks again for watching. If you have any questions, like I said, drop in the comments or send me an email, and do something kind for somebody today, and catch me down here at the beach tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.